confined. In India, this privilege is expressly guaranteed by Article 105. This privilege is confined only within the parliament and not outside it. Article 12 imposes a restriction on such privilege. Article 121 prohibits any discussion in parliament with respect to the conduct of a judge of Supreme Court or a High Court in discharge of his duties, except when a motion to present an address to the President for his removal is under consideration. In England, this privilege of House of Commons is well defined. Privilege and immunities of legislature and its member. This privilege is expressly guaranteed by 105 article. This privilege is confined only within the parliament and not outside it. Article 12 imposes a restriction on such privilege. Article 121 prohibits any discussion in the parliament with respect to conduct of judges, judge of Supreme Court or High Court in discharge of his duties, except when a motion to present an address to President for his removal is under consideration. Right of publication of proceeding. Article 105 clause 2 expressly provides that no person is to be liable for any proceeding in any court in respect of publication of any report, paper, votes or proceeding by or under the authority of the House. Protection under this article does not extend to publication made by a private person without the authority of a House. Article 105 clause 2 expressly provides that no person is to be liable to any proceeding in court in respect of publication of any report, paper, votes or proceeding by the authority of the House or under the authority of the House. The protection under this article does not extend to publication made by a private person without the authority of the House. In Surendra versus Nebraktisha, AIR 1958, Odisha 168, editor of a newspaper, was held guilty of committing contempt of court for publishing a statement made in the House without the authority of the House. See also Stockdale versus Hansard 1839, 8 LJQB 294. Constitution 44th Amendment Act 1978 has incorporated a new Article 316A into the Constitution, which provides that no person shall be liable to any civil or criminal proceeding in any court in respect of the publication in a newspaper of substantially true report of the either house of the parliament or of a state legislature unless the publication is proved to have been made with malice. Constitution Amendment 44th Amendment Act 1978 inserted a new Article 316A into the Constitution, which provides that no person shall be liable, a person shall not be liable to civil or criminal proceeding in any court in respect of the publication in any newspaper of substantially true report of either house of the parliament or of a state legislature unless the publication is proved to have been made with malice. Other privileges: a member of parliament cannot be arrested or imprisoned during the session of parliament and for 40 days before and after 40 days and 40 days after the session. Before 40 days and after 40 days of the session, a member of parliament MP cannot be arrested and imprisoned during the session of parliament after 40 days or before 40 days. These privileges is available only in civil cases, not on criminal charge or for contempt of court or from preventive detention. That means this privilege is available in civil cases only, not in criminal charges or for contempt of court. If MP has charged with the offence of contempt of court or criminal charges, accused of criminal charges or for preventive detention, then there is no protection available. Only in civil case protection is available. In K. Anandan Nambiar versus Chief Secretary Government of Madras, AIR 1996, SC 657, the petitioner member of parliament were detained under DIR 1962. Court held that if a member is detained under a valid detention order, the member can claim no special status higher than that of an ordinary citizen. In this case, particularly with a case named as K. Anandan Nambiar versus Chief Secretary Government of Madras, AR 1996 case, the petitioner who was member of parliament, who was MP, he was detained in under DIR 1962. Court observed that member is detained under valid detention order. If there is a valid detention order, Member cannot claim special status than an ordinary man. He will get only that status what a citizen of India can avail. He cannot be put in a higher position than a citizen of India, than a normal ordinary citizen. Number two, right to exclude strangers. This is very old right. Right to exclude stranger is a very old right. House can disallow any stranger person to attend its proceeding. House can disallow stranger person, unknown person to attend its proceeding. Number three, right to prohibit the publication of its report. In England, the Parliament enjoys this power to prohibit the publication of its report. In a famous searchlight case, MSM Sharma versus SK Sinha year in 1959, SC 395, the question was whether the publication by a newspaper, of a part of the speech of a member made in the House, ordered to be expunged by a speaker, constitute a breach of the privilege of the House. The Supreme Court held that it constitute a breach of the privilege of the House. Number four, right to regulate internal proceeding. There is a right to control the internal proceeding. The House has an exclusive right to regulate its all internal proceeding and to adjudicate upon such matters. In India, Article 122 says that the validity of the proceeding in Parliament cannot be called in question in the court of law on the ground of any alleged irregularity of proceeding. In MSM Sharma versus SK Sinha searchlight case AIR 1959 SC 395, the Supreme Court observed that the validity of the proceeding inside the legislature of a state cannot be called in question on allegation that the procedure laid down by the law has not been strictly followed. Number 5, right to punish members or outsider for contempt. It is the right of the House to punish member or outsider for contempt. The House is sole judge of the question whether any of its privileges has been violated, infringed. The court cannot question the decision of the House. The House question is the ultimate. There is no question over it by any court. In a famous case in the Privileges and Immunities of State Legislature AIR 1965 SC 745, Keshav Singh, who not a member of the UP Assembly, was held guilty of contempt of House and was sentenced to imprisonment for 7 days. On behalf of Keshav Singh, Mr. Solomon, his advocate, moved a habeas corpus petition. The petition was released by bench of 2 judges of the Allahabad High Court. The Assembly then passed a resolution that the Keshav Singh and his advocate Solomon has committed contempt of the House and directed Keshav Singh is taken into custody and the 2 judges and the advocate be brought into custody before the House. The 2 judges moved the High Court under Article 226. The petition was heard by a full bench consisting of 28 judges, which passed an interim order directing the stay of implementation of the resolution of the Assembly. The President of India referred the matter to the Supreme Court for its advisory opinion. Supreme Court held that the court in India can examine the validity of the detention of a person sentenced by the Assembly. In construing the power and privileges, other provision of the Constitution must also be considered harmoniously. Article 226 confers wide power on the High Courts to issue writs of habeas corpus against any authority, which includes the legislature also. Yes, so judiciary is more powerful. By this case, it can be observed. The judge is the sole because judiciary is more powerful. You have to again listen to the whatever I told you. Fundamental rights and freedom of speech under Article 105 compared. Article 19 Clause 1, a guarantee of freedom of speech has been provided to the citizen of India. The privilege under Article 105, privilege of speech and expression, is available to any member of the House. This privilege can be exercised only within the 4 walls of the House and not outside. The privilege in the Part 3 of the Constitution is subject to certain restriction. 19 Clause 2 to Clause 6, but the privilege under 105 is not subject to such restrictions. So that's all about these privileges of the House. If you find it useful, like, share, subscribe my YouTube channel for more such educational legal content and subscribe.